All right, everyone. The Supreme Court sadly has not decided to uphold the First Amendment by taking on the Novak v. Parma case. This is an Ohio case. Anthony Novak had created a Facebook page mocking his local police force and shitposting. Like, no reasonable person would have looked at the page and the posts that are archived that were there, that nobody would take it seriously and think that's actually the Parma Police Department. Saying like, don't give things to homeless people. We've got a new hiring initiative. Minorities need not apply. Stuff like that that's clearly off the wall. He has a gripe with the police, doesn't like them, and so he's clearly satirizing them. Now, satire is protected under the First Amendment. But it clashes, unfortunately, under the auspices of policing, with something called qualified immunity, which is what they're leaning on to defend themselves here. And SCOTUS had the opportunity to take up the case, where actually Novak was ruled against by the federal court involved. And SCOTUS has bounced it. They've declined to even hear the case, effectively allowing the cops to harass this man, jail him for 4 days for interfering with police activity, despite the fact that, again, no reasonable, sane individual, and what a reasonable person would conceive of in a given moment of time, often comes to play in court cases. So, for example, there's a fine line, potentially, between satire and defamation. If the claims you're making about someone are totally off the wall, such that a reasonable person would understand that it's humor, then the defamation case probably doesn't stand. Like someone says, well, he's actually a mad scientist. He has a death ray in his apartment. He's planning to take over the world, He's a real evil dick. Nobody would find that. They would understand that that's humor. A reasonable person would understand that. If you say, well, I hear that he diddles kids and abuses puppies. He's a real sicko. He's got a bunch of illicit images around his apartment. That could be defamatory. Now, of course, in some cases, for some reason, you still have to prove damages from it, which is a pile of baloney too. But cops, apparently now in the United States, under the auspices of SCOTUS deciding not to take this case up, the lower court ruling, at least in that district, will hold, can arrest you for interfering with them, for satirizing them. So no more cop block phony knockoff pages to ridicule people. It's like when people create a Twitter account that's dedicated to, and it's listed as parody. You have to do that, by the way. If you're doing it on Twitter, you have to explicitly make it clear it's a parody account. No more, I guess, pretending to be, a federal agent or something like that, because then you'll get a knock on the door. But it won't be a knock, it'll be a battering ram at 6 a.m. He was jailed and held for 4 days. He was eventually acquitted. They said, well, no, this is not really interfering with police activity at all. It's a satire page, and it's protected under the First Amendment. He then countersued. He said, well, the cops violated my constitutional rights. So now we've got a case where even if you are almost certain to be acquitted of any particular charge that's given for such behavior, unless the community doesn't like you, of course, the cops can come in and jail you for criticizing them in any way, and there's nothing that you can do about it because of qualified immunity. Sort of like civil asset forfeiture now, isn't it? Shouldn't be a thing. It should end completely. The Constitution is fairly clear on free expression. Criticizing the police is not legally actionable, or at least it wasn't until now. And it's very unfortunate that the Supreme Court, which is doing a good job largely on guns, it's doing a good job largely on many issues, but on the First Amendment, they're like, well, there's no underlying case law for us to consider here. There's no precedent that he should be able to sue because of qualified immunity. Well, then get rid of qualified immunity. You're the Supreme Court. This is your job. There's a clear and egregious abuse of the First Amendment, of the rights of this particular citizen, and others have fallen prey to the same thing. A reasonable person would never speculate that he had broken any law or done anything wrong. Well, then uphold the First Amendment. Oh, what the fuck else are you there for? You're the Supreme Court of the United States. Overturn the lower case and make it clear that a clear parody, something that is obvious in its parodical nature, is explicitly protected by the First Amendment. It's not impersonating a police officer. He's not using this page to say, hey, knock it out. I see you over there doing illegal things on your property, and thereby impersonating. It's just criticism. It's criticism in the form of satire. So hopefully they'll grow some balls and the next time they inevitably at this point have to take up such a case, eventually something will snap and there will actually be a social movement in favor of ending qualified immunity for the purposes of clear-cut, absolute satire. By the way, this is the case that famously drew that brief from The Onion, which they put forward. Dozens and dozens of pages of pure gold, absolute pure humor. I'm surprised that the court didn't uphold Novak's suit simply because the brief was so goddamn funny, the amicus that was filed by The Onion. I know I would have. I would have been laughing too hard probably to do it, though, if I was the judge on that case. A little bit of an ignominious position to have to be in. That's about all. Peace out.